Hello, thank you. Welcome. My name is Marguerite Almeida, and I'm one of the founders of Westwood Gallery, along with my co-founder, James Bello, president, curator, and we also have on our team Donna Altman, Jackie Phillips, other members of our team are all here. And first of all, we want to thank you. This is really great. Our gallery is in its 26th year. I can't believe it. It's gone by so fast. We purposely located ourselves here on the Bowery. The Bowery is a very historic area known for, I think, over 400 artists that have lived and worked here on the Bowery today, maybe starting from the 1940s. And so our program deals with much of that. We have rediscovered many artists who maybe are and have been underrepresented. So they've become a very big part of our program. We're very much about research, understanding history, and how the artist's work integrates into history along with their process. We work with many museums worldwide. We have a number of projects going on right now. And so we're really very, very pleased to host this event tonight. The Center for Art Law is a nonprofit organization, and we very much believe in what they're doing. Over the years, we have many artists who have asked us for advice, especially many senior artists in this area who need assistance when it comes to their actual artist estate. And so it's very good to have a place for them to turn to. So I wanted to introduce the person who was the bridge for us for hosting this event, and Atreya Mather, who is the Director of Legal Research at the Center for Art Law, and she will introduce them.
Hello, everybody, and welcome to our distinguished lecture tonight. And thank you so much to Donna, to Marguerite, to the Westwood Gallery for hosting us and making this possible. Just as an introduction, we were looking for places where we could host this lecture. And through my research, I saw that a couple of years ago, Westwood Gallery had hosted a very special exhibition of Andy Warhol. So we thought that this would be a great place to have this conversation. And as an introduction of the center, we are a non-for-profit research organization. We're based in Dumbo, Brooklyn, and we host tons of webinars, conversations, connecting artists, lawyers, appraisers, anybody from the art world together. And we have a lot of our board members today. We have our founder from Zurich right now, who is with us, Irina. We have our fellow, James Parker. We have a good number of our board members, Raquel, Carol, Evie, and a lot of our interns. So we'd love for you to stay during the networking reception. We'd love to speak with you, let you know what we're working on. And we're always very excited to hear from you, to know what you would like us to be working on. So if you want us to talk about immigration or estates or NFTs, we will definitely be doing that next. Now, without any further ado, I want to introduce Nikas, who is our speaker for today. He's a partner at Quinn Emanuel, and he has represented artists, art dealers, auction houses, I think everything. So you can read about Luke in the handout and materials for today. You should have received an email with his bio and more information about him, as well as additional and suggested reading materials about the Andy Warhol case, about the Richard Serra case, and other interesting news books that we think you might like. So feel free to take a look at the handouts. There's a QR code, which we'll pass along once as well in case you don't have access to it. But I will now hand it over to Luke. Thank you so much, Luke.
Everybody. We're in a small room, but you should be able to hear me okay. You good?
Yes.
Okay. So I just want to thank everyone for coming. The Center for Art Law reached out to me and asked if I'd give a talk to help support the work that they do. It was an easy yes. The work that they do for artists who are in need of advice to the general community, educating them about developments in art law. It's just so central to get out what we do as lawyers, what artists do as artists, the issues they face. And so really thank you all for coming tonight. When they asked me to talk about fair use, the first story that really comes to mind to me is about 20 years ago, I walked into a museum and I didn't know a whole lot about art. And there was a work on the wall that was all black. And I looked at it, tried to understand what was going on, and I couldn't. And I looked at it and tried to understand the meaning and the message of the work or what market conceivably this black object could go into. And I thought, I have no idea what the meaning and message is. I have no idea who would buy this, but it's in this great museum. But I can imagine someone looking at it and saying, it's everything, but it's nothing at the same time, or some platitude. And I thought, this is all very, very silly. And then moved on and looked at Jackson Pollock and Van Gogh and other artists that made some more sense to me, although Pollock still didn't make much sense to me at the time. And then left. And then 20 years later, here I am talking about Richard Serra, and it's probably the work I was staring at and criticizing 20 years ago. And what really got me thinking about that anecdote is, what is art really all about? What is the meaning of art? How should we think about art? And where is the place in the world that can have a significant impact on the conclusions that we draw when we reach about those questions? And where I landed is the court system, maybe regretfully, but certainly the court system is a place that can have a significant influence on what gets created, what doesn't get created, what artists think about when they're creating work. Because if you answer those questions, what's art, what's it mean, in one way, what's essential to a work of art, in one way, you can end up with very different incentives across an entire country that artists think about before they put pen to paper or brush to canvas. And so the way I think it's interesting to illustrate this is Richard Serra. So end of the 70s, he gets commissioned by the GSA, Government Arts Program, through its administrative arm, to make a work for Foley Square. It's a plaza downtown in front of the federal courthouse, the state courthouse. And Serra creates this work right here. It's called The Tilted Arc, goes up in 81. And I put this picture. When I was thinking about art and its meaning, how to really capture the issue, I put this picture with a different lecture in front of groups at various different institutions. Really smart people. Sotheby's Art Institute, University of Virginia, University of Southern California. And I said, raise your hand if this is art. About half said yes, half said no. I said, for the people who say it's art, why is it art? And everyone gave a completely different answer. And I said, for the people who say it's not art, why is it not art? And they said, obviously, it's a big, ugly, rusted steel wall. This is clearly not art. And then I said to the people who said it's art, what does it mean? They said, well, it's in a plaza in front of courthouses. It divides justice versus injustice. It divides plaintiffs and defendants. It divides disputes. And some people said, I think it represents the meaning of life. And they gave some answer, and everyone had a different answer. And so then I said, does that give you any more information? Let's zoom out and give you some context. That's the plaza. The courthouse you see directly across, the state court of New York, and then the federal courthouse is the one on the right. And they said, now I have a different answer. That context is helpful to me. I see that this is a plaza, and you're supposed to commune, you're supposed to bring people together there. And this represents division. A lot of other different answers. None of the answers were even remotely close to what Richard Serra said about the work. What he said about the work was, I walked around this plaza and I saw beautiful architecture, these great buildings, these grand courthouses, and I saw everyone, the equivalent of staring at their phones today, I saw everyone heads down, walking to where they needed to go, point A to point B, and I wanted people to stop and look around. and think about their surroundings and take in this beautiful architecture. Right? He does site-specific work, and he takes in the site. No one at all said that's what they interpreted when they were looking at the work. And interestingly, we don't just have anecdotes like the one I just told you about. There's a lawsuit about this because after it went up, I can't read that, so I'll just talk, and if you can, great. But after the work went up, there were an enormous number of complaints. The Chief Judge of International Trade, the courthouse that you couldn't see on the side from the perspective of the photograph, said we used to have this beautiful plaza. Now we've got this big, ugly, rusted steel. People complained that the wind pushed garbage up against it. So this is rusted, this is hideous. I used to be able to walk to work, now I have to walk around this thing. This is terrible, terrible, terrible. And some people, referring to rust, said that's a beautiful golden patina. So everyone had a different impression, a different understanding, a different feeling about what this work was. And so in connection with this lawsuit, where Sarah said, you take down my work, because that's what they were saying would happen, you violated my First Amendment rights. I didn't really care about that piece of it. What I cared about is in the hearing testimony related to the work, there were all these explanations of what people thought it meant and what it meant to them. There were the numbers here, 654 pages of testimony, 7,412 petitions, 1,779 letters about this work. Everyone had a different thing. Take it down, destroy it, leave it up. It's amazing. One of the iconic works of our city. And so if we've got New York City, some would say a cultural center, if not the cultural center of the world, and we can't even agree on one of the most significant artists of the 20th and 21st century, what he created is art, what does it mean? How are we going to deal with these issues when courts have to address the same thing? So I said, well, let's look in the New York City archives to see if we can build out a broader profile of what people think about art. And so I looked at the archival records, and the Department of Employment says the arts are a labor-intensive industry characterized by chronically high unemployment and underemployment. I thought that doesn't seem like a definition that should drive outcomes in cases. And so the Department of Cultural Affairs says an artist is someone certified by them alone. I thought maybe that's true, but that doesn't help us much either. Elsewhere in the archives, art by definition defies consensus approval. And I thought, also true, but we need to reach consensus in these cases. Even if there's division, we need to reach consensus. A jury does, a judge does. And so this is the problem that we're starting off with when we think about fair use. And so then we ought to think, what are we trying to accomplish in the first place? And there's all this talk about meaning, message, look at this Kuhn's work. Does it interpret the photograph adequately? Does Warhol work? Does it transform the Goldsmith? All these words that don't have a lot of meaning and are disconnected from the purpose. And so many people know, but not everyone, is that copyright and fair use derive out of the Constitution, copyright in particular, where the purpose of copyright is to promote the useful arts. And so if we think about copyright cases, the Warhol case, which I'll talk a bit about, and some others, as creating rules that we ought to adopt with a mindset of promoting the arts, incentivizing creation, then maybe we ought to think about what rules we need to do that. Clear rules, not confusing rules, because you're not going to incentivize someone to do something unless they understand the incentive, unless they understand the boundaries of how far they can push. And to that point, the boundaries. So we want to create incentives for the original creator, but we always are building on people that came before us. We always are borrowing from other people. We're borrowing ideas, we're borrowing our language. We need to figure out not only how to incentivize that original creator so that that person doesn't think if I create something, someone else is going to steal it from me. And what's the point? Because then I've got no economic incentive to do this. And remember, see the definition of artist according to the Department of Employment. The economics do matter. And we need to say, for the person who's going to borrow, this is what you can borrow as clearly as we can tell them, and create something new for them to contribute to the useful arts. Because if we don't do that, we don't create that clear rule, then that person's not going to borrow, so we're not going to build on what came before. And the original creator is not going to create because they're going to fear that someone could borrow and it's all ambiguous. And so those are just the fair use principles. And so it's been a roiling debate for decades. Jeff Koons has gone through some of them. He takes a photograph of a couple with a group of dogs sitting on their laps, and he transforms it, I use that word very delicately, it's lost the case, into a sculpture of a couple with dogs across the lap, and the second circuit says, no good, not transformation. Then we have Carey versus Prince, which I still can't make sense of. And Carey versus Prince, this really illustrates something important about who is deciding these cases and declaring. So the judge in the district court case in Carey, Judge Deborah Batts, incredibly smart, respected judge, Harvard Law School, Southern District Clerk, practiced at Cravath, big white shoe firm, assistant U.S. attorney, associate professor at Fordham, and she was at the Department of Investigation as a special associate counsel. Now, I'm going to fast forward for just a second so we can look at the district court judge in the Warhol case, which at the district court level came out the opposite as the Carey case. Carey said destroy works at the district court level. In the Warhol case, it was a fair use. John Coble, brilliant judge, Harvard Law School, clerked on the Southern District, Watergate special prosecutor, private practice at Denver Boyce, a peer firm of Cravath. So extremely similar backgrounds in terms of education of these two judges and post-Harvard work. Two opposite results, completely opposite. So Prince says, Carey took photographs of the group of Rastafarians. Prince made works out of these photographs, some collages, some not, some with lozenges on the face of the Rastafarians. And so the Second Circuit says what we need to do is we need to figure out how a reasonable person may perceive these works, or how may they be reasonably perceived. Again, looking at meaning, looking at message. And the Second Circuit says, as a matter of law, this combination, Carey on the left and the Prince on the right, Prince made fair use of Carey's photograph. So you can see, looking at it, you've got the same animal, the same man on the right in the Prince work. You've got the same background, slightly lighter, but you've got the same background. You've got the same man sort of duplicated, reproduced on the right with some lozenges. But you recognize that the Carey photo is the foundation for the Prince work. No one looking at those side by side wouldn't say that's the foundation. He took the photograph as the foundation and he added to it. Two pictures, one on the right, one on the left. Those two women. But this is not a fair use. Well, let's see if we can find differences. Same man twice. There's one picture of a woman on the right collaged in, but not on the left. Apparently, you need to have two pictures collaged into a work, not one, in order to make a fair use. I cannot explain in a principled way why that is a fair use as a matter of law, and this one raises a question that needs to go to the court. I can't. I've thought real hard about it. You can find distinctions, but I can't find distinctions that matter. I can't find distinctions that, when you go back to the opening question, that define why this one's art and this one's plagiarism, or why this one's art we want to protect and incentivize, but the other is not. There's, in my view, no explanation. How may a reasonable person perceive that versus that? Can't do it. So we continue on, and in the Keenan's case, the guy on the left was a mayor of Madison, Wisconsin, And he apparently partied too much. And so an artist took his photograph that had been taken by a photographer, made by a photographer, and screened it on a t-shirt and said, "Sorry for partying," across the front of it. Funny, political-oriented message. And he did what basically Warhol did. He created a high contrast screen of his photograph, the photograph, where all the darks become black and the lights disappear. Screened it on a t-shirt, use some exotic colors, and then put the words on it. Kinitsu versus Scotty Nation, which is the printer of the t-shirt. Kinitsu says, "You've ripped off my photograph." And the Seventh Circuit, Judge Esterbrett, highly respected judge, says, "I don't really want to talk about," not his words, mine, "I don't really want to talk about the meaning or message of this work. That's all just very confusing, leads to inconsistent outcomes," doesn't say it, but certainly built a decision. He says, "What I really want to focus on is what was taken from the original and put into the appropriation work. Was it important? Was it essential? Is it copyrightable in the first place?" And Estabrook says, "Well, the original's background is gone. Its colors and shading are gone. The expression in Sovereign's eyes, it's the former mayor, can no longer be read. After the posterization and reproduction by silkscreen, the effect of the lighting in the original is almost extinguished." And then notes, "We're talking about an outline of his face. You can't copyright the outline of someone's face. So this is not an infringement, according to the Seventh Circuit, for those reasons." And so you may disagree or not with that decision, but it starts to make some sense, because we're not talking about how do we interpret the meaning or the message of the t-shirt. We're actually looking at the art itself and figuring out if the art itself on the right borrows the essential elements of the art on the left photograph. And the Seventh Circuit says, no, the essential elements are gone. But what are those essential elements? The court's defining. We haven't an answer yet. Enter the Indy Warhol case. So the Indy Warhol case starts historically in 1981. Lynn Goldsmith is a photographer, well-known photographer, incredibly talented. And she takes a lot of photographs, she corrected me every single time I said it in that position. She makes photographs of mostly rock and roll stars. So in 1981, Prince is not yet at the top of his game. He's not the superstar he was 3 years later in 1984. He was getting there. And at that time, Goldsmith tells me she listened to his music. She thought about who he was, how, as a real person, not some icon that we were not yet worshiping, but about to start worshiping, what he was and who he was at his core, if you really knew him as a human. And she went into a shoot. It was at her studio. And she said Prince was vulnerable, scared. Came out, she took a few photographs. And then Prince went into the dressing room, didn't want to be photographed anymore. Shut the door, was scared. And Goldsmith knocked on the door and coming out to continue this shoot. And she realized he was uncomfortable. And she said to him, if you'd like to leave, that's okay. I'm going to leave the back door open and step away. And she did that and he left. And so she just had this handful of photographs that she made of Prince. And that's it. When you ask her to describe them, she says basically what you would imagine he was feeling and she was experiencing in that shoot. Vulnerable, scared. He wasn't the Prince we all know today. He wasn't the icon. He wasn't the star that we see him as, that people worship. 3 years later, 1984, that had changed, at least on the surface. And for Warhol, as it said before, that's what matters. What's on the surface is what matters. That's what I'm trying to capture. So in 1984, Vanity Fair reaches out to Warhol somehow, some way, we don't have any record of it, and they reach out to Goldsmith separately, and they tell Goldsmith's publishing company, we want to license a photograph for use for an artist's reference. They don't tell her who the artist is, they don't tell her what the article is, they don't tell her any information at all other than that. She signs a rights agreement to license a photograph for an artist's reference. Warhol somehow gets this photograph, again, no record whatsoever, and he makes 16 works. So as you can see, the bottom right, there are 2 line drawings, the third row down, 3 and 4 over, and then there's one on the top row as well. So Warhol's process was to figure out through his method how to eliminate as much of the person as possible. How do I create an individual who's not really a person that we know, not a person that we want to understand, but who really is a stand-in for some concept. So for celebrities, as I'm sure all of you know well, he was looking to demonstrate a couple of things. One, how we all take in celebrity imagery. So we see celebrities all the time on the news, in magazines, etc. But we don't really know them, even though we feel like we do. Sort of that feeling when you're with a celebrity that you've never met before, and you feel like you know them. It's a very weird feeling, but you really don't. You just know the image that's repeated over and over and over and over again on the news, and that you sort of internalize as a person you actually know, but you really don't. And Warhol said, I want to capture that. I want to capture the repetition of imagery. The fact that we don't know these people that feel like their lives, but we ultimately do worship them. We think about them as these icons, as these stanzas, or some principle, or some creative endeavor we're all behind. And so the way he did that, in part at least, was he'd take a photograph of a person in a well-known pose, whether it's Muhammad Ali holding a fist, or Marilyn, not some pose where you wouldn't recognize the person. Well-known, has to be front-facing, has to be clear. And then he would do a line drawing by projecting the image against either a wall or some kind of desk, and he just sort of line draw, roughly, the outline of a person's head and major features. And then he would experiment with that line drawing to figure out how he actually wanted to appear, where he wanted to crop it. You can see in the one on the right-hand side, third row down, you've got the suspenders, sort of sash. On the left, you've got some different texture in the bottom of his tendrils of his hair, and you have on the upper right, so experiment with what he wanted to create as the ultimate output. And then he'd take a canvas, if it were a painting, he would prime it, he would paint it, color field style, and you see a lot of the different imagery here and choices he made with respect to background. And then he would take that photograph, and he would screen the photograph onto, or create a silk screen using the photograph. And the way he did it is he'd first take the photograph, take a China marking crayon, and he'd mark it up and say, where do I want the head to appear? It's very important that the head be front, be right in your face, not be set back. And so he'd draw exactly where he wanted the photograph to be cropped. And then he'd create a silk screen using that cropping, basically using transparency paper that doesn't exist anymore, that we used to have in elementary school, and would adjust the cropping and adjust the contrast. And then he'd screen that on top of the painting, or the canvas that he had prepared. And so now you've got the image on the canvas, and then he'd take those line drawings that he was experimenting with, and he'd use them to create offset line screens. So he'd go with the same process. Use the drawing to create the silk screen, and then he'd screen offset with the original image, the outline of the head. So what you're looking at is repetition of imagery. You're looking at the outline, you're not looking at the detailed texture of the person. And then he'd go through this process with multiple other works. And so he does this in 1984. One of them, on the top left here, the purple one, gets put into a Vanity Fair article, November of '84, by a guy named Tristan Boggs, not a real person's name. And the article title is Purple Fame. And so what's the point? Now Prince is the star. Now we've seen his image over and over and over again. And Warhol is apt for what he's trying to accomplish. Not the Goldsmith, the Warhol. Because this is not a vulnerable prince. This is a bold prince. This is a prince who's facing forward, who is one-dimensional. This is not an individual we know or care about in the flesh. And so that's basically the end of Warhol's interaction with the Goldsmith works and Goldsmith's knowledge of what had happened until Prince dies. And at that point, Vanity Fair reaches out, and Condé Nast reaches out to the Warhol Foundation and says, we want to license one of those Warhols for the cover of a commemorative edition magazine in which we're going to commemorate Prince's life. And we want the right. That just defines who he was, what Prince did, and the impact that his celebrity had in the world. And we want to think about celebrity in the way that the Warhol defines it. And so it goes on the cover. Goldsmith reaches out, she says, you infringe my copyright. $1,000, and I'm going to sue you if we can't sell this. And so ultimately we filed declaratory judgment action to avoid being in a jurisdiction we didn't want to be in, and to tell our story first, because we believe we were right and not wrong. The district court, Judge Cole, says this is a fair use. It applies period test. How can we reasonably perceive the Warhol? How do we reasonably perceive the Goldsmith? What are we trying to protect here? And does the Warhol work infringe on what Goldsmith did? And the case really revolved around both that analysis as well as the market analysis. Cole says, let's look at the Warhol. And let's look at Goldsmith's own words about the Warhol and about her photograph. In her deposition, I asked her, what did Warhol copy from your photograph? Did he copy the color? No. Did he copy the lighting, the shading? No, didn't do that. Did he copy the cropping? Oh, that's different. I said, what did he copy? She said, the outline of Prince's head. So if you remember the Keenan's case we just talked about, that's exactly what the Seventh Circuit, very prominent appellate court, and Judge Esterbeck says, not copyright. And then I said, what is photography all about? And she said, light and shade. Photography is light. And when you look at that, applying that test, and you look at the Warhol works, the lighting choices, the shading choices, completely different. Completely. Some of them don't have any light or shade at all, it's just the outline. So Judge Kodal says, now let's look at what Goldsmith said about the meaning of the work. And she said the meaning was to capture Prince as he was, a vulnerable person. In that moment, I told the story that I told you about what it was like to photograph him. His personality, how he interacted with her, he was shy. I said, do you see that in the photograph? She said, absolutely. It's actually hard for me to look at these photographs because that brings me back to that moment where he was shy. It makes me sad. Well, how about the Warhol? That's not his message, not his message. And so in transformation, we've got meaning and message very different. We've got ultimately a different aesthetic transformation. And the markets generally for Warhol and Goldsmith generally are different. She sells to different types of collectors, to different types of galleries who focus on rock and roll memorabilia or artwork. She sells at completely different price points. And the way that her works are sold is very different as well. She emphasizes the historic moment of capturing that musician. For example, if you've been to a concert with that musician and you want to have a photograph of that musician in concert, so recreate the moment you had. Those are the messages, those are the sales practices that she uses to sell. Warhol, obviously very different. If you look at, and we have an expert testify, about Christie's gallery. They talk about repetition of imagery. They talk about the way we do memory recall. We recall just general outlines of things, surfaces of things, so the principles underpinning advertising. You see it enough times, you know why. That's very different from the purpose. And so Cole ultimately rules meaning and message different by her own admission. The underlying aesthetics are different. A reasonable person may perceive these as different. We go to the Second Circuit, and the Second Circuit disagrees about as firmly as you can disagree. But the words that it uses are really intriguing. So the Second Circuit says the district court shouldn't assume an art critic, and then goes on to assume the role of an art critic. When they do that, they say Warhol's signature style, the elements of which are absent from the Goldsmith photograph, are present in the world. I see that. But that's no different, the court says, from looking at a film and identifying that film or recognizing that film to be by a particular director. But that doesn't mean, as a general matter, that the director can just rip off a novel that someone's written and make the film. The fact that the director puts the touch, the style that that director is known for on the film doesn't protect it from infringement. And that's what's happened here. This is Warhol's style. He just layered it on the Goldsmith, but he didn't change anything essential. And the court uses that word quite a few times. Crucially, the Prince series retains the essential elements of the Goldsmith photograph. Unlike Prince, which suggested an entirely distinct artistic end and pulled them in new directions. In contrast, adding to that part, the Prince series retains the essential elements of the source material. The Goldsmith photograph remains the recognizable foundation upon which the Prince series is built. And so if you read that decision, and then you go back to the initial question that we're talking about, how do we understand that? And you try to figure out, using this decision as your guide, what the essential elements of the photograph are, you'll be as confused as I was looking at the carrier comparison, because I can't find any credible explanation about what the essential elements of the photograph are. But it got me thinking that if we can all figure that out, if perhaps understanding the core of a particular medium or body of work is easier to understand than defining the meaning or message, which definitely defines consensus, then maybe that is a way to understand this question and to create clearer rules. And so with that, you can see, when you look at some other cases that have come in, how doing anything else is not going to help us. So the Murano case versus the Met Museum, this was decided within a week of the Warhol decision. And what happened was there was a photograph of Van Halen in performance. And the Met took that photograph and stuck it on the wall. Not a different photograph, the same exact photograph. Didn't change a single thing. But had some other imagery on the same wall and in the same exhibition related to Van Halen's guitar. In the Second Circuit, it was less than a week after the Warhol decision. It might have even been a few days. My head was spinning when I read this one and said, I wish I had that panel. The court said, that's a fair use, because even though it is the same exact photograph, literally without change, the context is important here. The photograph was focusing on Van Halen in performance, but the exhibition was about Van Halen's guitar. Because look at all these pictures of guitars. And I thought this is not a principled way to make a decision about whether this is infringement or not. Because clearly, the essential elements of the photograph that we met are the same. It's the same photograph. We didn't change it. Clearly, it's the foundation upon which that photograph was created, because it's the same photograph. There's a whole lot of context in the Warhol case, too, that didn't seem to matter. But now, all of a sudden, in the Murano case, it does. And I say this without regard for whether you really love fair use and think it's a great thing, or whether you think it's a terrible thing, and you'd be more aggressive or less aggressive in how you define it. I say this from a point of clarity, going back to, what are we trying to incentivize? The Prince case starts to get it right. In that case, we've got the original photograph by Graham. We've got Prince on the right, where Prince just replicates the same photograph and creates an Insta feed and puts some nonsense at the bottom of it that no one understands and that reports to, and says, here's my work, and Prince it. Now, you might say, look at this Prince, this is commentary on the influence of social media in our lives. It is commentary on the use of images and how our digital world has changed the way in which we interact with people, the way we interact with art. You could come up with a whole lot of explanations. The district court, same Southern District Court, different judge, as the other cases we've talked about, Kerry and Warhol, says, let's look at that composition, presentation, scale, color palette, and media used by Graham, and let's look at those in the Prince work, and let's figure out whether there's a distinction, whether there are significant modifications or not, and we'll look at the market too. But let's look at these components. And it doesn't say, because those are the essential elements of photography, but they matter to this court. Perhaps because that's what people look at when they reasonably perceive, defining what someone can reasonably perceive in the work, perhaps for other reasons, but this is a start. And so, if we look at different media, if we look at photography, if we look at novels, if we look at painting, if we look at music, and these are not fixed, these are subject to change, and we figure out what is the core of the art. So if I ask Lynn Goldsmith, what is the core of photography? She'll say light and shade. And you know what? A lot of other photographers will too. They'll also say lens choice to the extent it impacts how the work appears. They'll say cropping, they'll say overall scale, color palette. But light and shade are the core of it. And the other elements, these factors of what we're trying to protect. When an artist makes a decision to create something, what are they deciding to do? Now, they decide whether it's canvas, whether it's paper, they make choices, but when you ask them, what were the artistic choices that you made when creating this, that you want to protect, that you're most proud of, and you break it down into different art, you will get a remarkably consistent, not uniform. Some artists will look at this list and say, no, strike that off, or add this or that, but you will get a remarkably consistent view. Look at novels, change of fortune, problem in the story, complications, crisis, climax, resolution, threat. You look at those artistic choices the novelist makes to define a novel. And then you can take that and you can look at a film and you can ask yourself, did the director put a stylistic touch? Yes, no. But did the director change the fundamentals of what the novelist created? Or is it basically the same story? You can't create a movie, change, you thought it was going to be a man, but it's a female instead. You thought it was going to be a tall person, but then it's a short person. You can't create a movie where you change things like that you might infer from reading the book. But steal the whole story and say it's protected, and the movie is protected. But you can make a movie that changes the fundamental artistic choices that the novelist made. Borrowing some, but not taking the core of the work. Painting, same thing. You can come up with a core of what it means to make artistic choices when you're painting something. Music, ask a musician, ask a artist. What's the core artistic choice or choices you're making when you write a song, when you sing a song? And if we could define art better, if we can come up with a generally accepted list, always going to be disputes, a generally accepted list, or at least a defensible list of the essential elements of the art, then making these comparisons of what was created originally, do we want to protect it, what was borrowed from that, and does it invade the sort of core artistic province that we're trying to protect in the first place, then we can do a much better job of creating a fair use doctrine that's responsive to what the Constitution was designed to create, the incentives that we want artists to have, and most important, whether you like fair use or you don't, that gives clear guidance to artists. Because as I said, the real issue here is we've got lawyers deciding cases and arguing cases that are going to have an impact, most important, on the artists that are going to be subject to the rules. And then we all suffer as a society that cares about art and culture if the artists are so disillusioned by the rules or concerned about them that they don't agree. So that's, I think, a better way to approach fair use. I have no predictions on the Warhol case. If I did, I would not say them publicly. But what I can say is that the entire process, start to finish, the entire historical arc of the fair use cases makes cases like this so important because the impact they will have. And unfortunately, the courts have not been given the tools in order to decide them with this level of clarity. So that's all I have to say, unless you have questions.
I have a question. Our spending my days researching on the differences of interpretation of the meanings of art in courts. So this is very much in my alley. I am very interested in your insight in terms of if there's any institutional framework coming in to provide that to your say to determine arts, especially when you're talking about you're using maybe photography, maybe architecture, sculpture, painting as the example of arts when was the innovation of technology, ARs, and then all new sorts of art, neon, and thinking about these different frameworks are completely different dialogues about material studies, historical studies, and how that may have played in an institutional framework has ever been considered, or at least the field of art industry has been considered.
Sure. So this really raises two questions. One is, what role should that approach from the institutional side play in a case? Or do we want to have institutions define what it means to have core photography? What should we do? And when you look at the cross-section of institutions that have been involved in cases like this, and they usually come up because they file briefs in support of one side or the other. None of the institutional focus is on this. It's on fair use is confusing, fair use is problematic. If you rule in X way, it's going to destroy the arts and our supporting group. And so you've got a group of photography associations taking that position on one side, and then you have a group of, whether it's artist foundations or museums taking the other side, and then you've got a group that are in the middle. And so the institutional focus is then less on what are we really talking about, and more on what's going to happen if you rule for this side or that side. The other piece raises a second question: what role should experts have in these cases directly? And so both sides in litigation can hire experts. We hired an expert, a handful of experts, and our experts explained that this is what Waddle does, this is how it does it, there's the market. And the interesting thing is that Goldsmith also hired an expert on the market, the comparisons, for example, and our expert rebutted that. And we filed a motion to exclude her expert. In the Second Circuit, and Judge Kohl in the district court said, I don't even need to look at those expert reports because this is just so clear based on all the other evidence, like the aesthetic changes, the message changes, etc. The Second Circuit said Goldsmith's market expert was unrebutted. Didn't carefully review the record to see that we actually had a motion pending and had challenged the expert with our own. But nonetheless, the Second Circuit didn't look to those reports at all as defining meaning, message, test, etc. And so one thought is, I'm not going to stand up in court and say, I, William Nikas, am going to tell you, Judge, the core of photography. And you can trust me, because I'm not a photography expert, and I can't testify for my own client. And so the answer is, I think it's less about institutional framework, institutions contributing, and it's more about finding experts in these fields who would be willing to testify, this is what photography is all about. This is the core of photography, the artistic choices that we need to protect.
I'm asking you to look into the future a little bit. If you thought about it, artificial intelligence is becoming so good, and it's going to create art. It's going to create art. Have you thought about where is it going with this as far as regulation?
Yeah, so the question is a really big one. So we can think about the role of artificial intelligence in all sorts of ways. case. In the way that it's normally been thought of is when a machine creates something, is it copyrightable? And there have been significant discussions about, well, is this original work? And does you have to have intent to create something? And all sorts of debate about whether a machine-created work is something that the copyright law protects. And that's all interesting, and it's going to present a lot of debates. I tend to focus on how do we figure out in the current fair use test whether a machine-created appropriated work infringes an original work that's clearly copyrightable. So let's think about this. What is the artist's intent and the meaning and the message of the appropriated work that a machine created? Who do I depose? I have no idea. Do I ask the person who wrote the algorithm what the meaning, message, and intent of the machine-created work was? Is that person going to be useful?
But artificial intelligence is based on historical statistics. That's the only thing that it's based on. Yeah, it's nothing about creating further. It's all about historical facts. I mean, to me, that sounds like it's a clear way of saying it's not possible. It's not possible to be copyrighted.
Well, it comes down to, is it possible to figure out what's copyrightable? And we just have to have a test. And maybe it's, yes, machine-created works are copyrightable because someone was behind the algorithm that created the work, and therefore there's some original creation, and we want to protect the person writing the algorithm that ultimately resulted in the product. Because if you say the product is not copyrightable, then what you're saying is just the person who wrote the algorithm, what you're doing is not protected because you didn't actually put pen to paper or whatever object is with the final work. And obviously we want to protect computer scientists too. And so the question then in my mind is, it should be copyrightable in most circumstances. But then, like I said, how do you apply fair use to it when the current test, you really can't in a way that I think is credible, meaning, message, etc. for the reasons I said. And so if I look into the future, I think we need to protect people who create the underpinnings of artificial intelligence because we want to protect the product of it. But we need to think carefully about how that should be appropriated and can be appropriated in society, which I also think we need to do, just as we would any other work or product. But we can't do it under the current fair use regime.
Do you think from a legal perspective, the fair use standard meaning message is just a little too broad and needs to be a little bit narrow and tailored? So subjective that it gets a little bit complicated?
It should be about the weight we give to it. So when you think about parody, when you think about Sherry, when you think about satire, we care about the meaning and message of art. It might be wrong to say, let's just focus on the nuts and bolts and not think about the artistic intent and the impact, because then you're sort of wiping out one of the most critical elements that defines in many ways what artists are doing. So the question is one of weight. And I think we should put less weight on the meaning or message of a work and more on the core of what we're trying to protect in the first place, because ultimately those artistic choices came from somewhere. And the way I think you get at meaning and message in a slightly better way is context, because context can really define what was going on in a better way that an artist, take the Jeff Koons situation, you look at the first Koons case, the Rogers case, he said basically, I've got no message, I've got nothing for you. And then the next case, he was very well prepared, and he said, let me explain my meaning or message. It's about commercialization and advertising, and he was a perfect lawyer's answer. And so it can be manipulated, and so I think we need to be careful about where it's coming from, how we're going to source it, and the weight it plays. So it shouldn't be irrelevant, but I think it should be a much lesser weight.
Two short questions. I heard some really smart people this morning saying they had a sense that the court has no real sense about fair use law. They didn't even know about the Campbell case. But I wondered if, I don't know if they will, but wouldn't it be wonderful if they would try to grapple with the issue of transformativeness, which has become too broad and everything is transformative. And that would be a wonderful thing because, you know, a different meaning, message, aesthetic has been interpreted to be too many things.
Well, transformative, part of the transformative tension, as they call it, is that you've got under the current law, depending on how the other factors a fair use played out market, how much of the work did you use? If you have created a work that's transformative, then that creates a significant thumb on the scale in favor of fair use. The problem is, if you're an artist who creates a work under the copyright law, you have the right to any transformed works. So let's look at the Warhol example, 16 works. You create the original, you own the original work. Let's say you want to go out in the world and change a little bit about one of those works. You can do that, and you own that work as an outreach or an extension of what you created before. And someone else who's doing that, who's invading your space, does not own that right. And so if something's transformed, you don't ultimately, you can infringe it. And if it's transformative, then it's not infringement. So this is very confusing. And so this goes back to labels. So what is the essential element? It's nice to say it in a decision. It's better to actually use the words that we're intending to convey by using the label. And so if something's transformative, that has meaning to everyone and different meaning to some, and certainly derives from rights that artists should have when they create. So I think it's not helpful, just like essential elements is there.
Remind me, was the image that was used in the second publication the exact same with the 16 images
It was
that
not.
was used in the first publication?
It was not. So all right, so the orange prints on the left is the one on the cover from 2016. The purple face prints 3 down on the left is the image that went into the magazine in 1984. So they were different. The interesting point that I think you're making is, what about all these other works?
Yeah, exactly. Because both court opinions, both Coto's court opinion and the Second Circuit, both focus on the work that was published in the magazine, but never address the other works at all.
And so all 16 works were found to be infringing, even these line drawings, the 3 that I showed you. And the way the court did the analysis was these 2 works, the ones I pointed out, were in magazines. Goldsmith is in that same marketplace. Her photographs are used in rock and roll magazines and other pop press. And so Warhol, even though he's in a very different primary market and secondary market, the reproduction of his images are arguably in the same market as Goldsmith's. And then did the link of, and there was no rebuttal expert in response to Goldsmith's expert, not accurate, and therefore it's agreed that this is the same marketplace. But what it didn't do is say, wait a second, what about all of these others, 14 others? None of them went in a magazine. In fact, a handful of them were donated to museums where they still hang on museum walls, and the rest were sold to private collectors, not ever in the same markets as Goldsmith, which raises a question that's, in my view, very confusing in terms of one of the implications of this decision. Let's say you create an artwork. You own the artwork. You own the copyright of the artwork. You created the image. It would be very complicated. Remember, we just talked about how if you create something, you've got the right in all these derivative markets. You can transform it, you can do a Seinfeld show, and then you can create a book about Seinfeld show, all the episodes. Like, you own, as the creator of something, the derivative uses of what you created. And so if you create a painting, you own traditionally the right to display the painting publicly. You have the right to take a picture of it and send it to a magazine, and the magazine publish it. In this case, the court, the Second Circuit, so narrowly defined the marketplace, but went on with respect to the reproduction of the magazine, but then went on to say, don't worry, museums, don't worry. We're not going to rip those works off the wall. That's a very different case. And if this case were about the works on the museum walls, we know by the way it was, explicitly, that picture on the right comes from a complaint filed. So there's no confusion. If this case related to the works on the museum walls, then we may have reached a different outcome. But then it goes on to find that all 16 are infringing. And so the question is, how do we define market? And what are those bundle of rights that you have as an artist? And again, more confusion in the way this decision came out because there are 14 other works and never made it into the same market that Goldsmith tried to define.
First, I want to preface my questions by saying that the artist is also the truest gender of the human condition. And so the first question is, how do you define the artist and the role? And the second is, were the circumstances 360 reversed? How would you define it?
How would I argue the Warhol or the Goldsmith side of it? Sure.
The first hasn't defined.
It's a good question. So for me, it's a bias consensus. For me, it's about the experience. So when, great example, Hank Willis Thomas, tremendous artist, in my opinion. He told the story to someone before talking with the owner. Created a work that is about big 35 by 25 or so. And all you see is a guy with his arms crossed. Black and white image of a guy. And around this guy with his arms crossed, you see sort of movement, but it's a total white screen across the background. And you have no idea who this guy is, and you're looking at it. It's on the same reflective material that we make stop signs out of, sort of metal, sort of plastic metal. And you ask yourself, looking at it, I ask myself, looking at it, who's this guy? Why does he have his arms crossed? Who are these people in the background? What are they doing? How do I care about this guy? Should I care about this guy? And then when you take a flash photograph of the work, the guy turns into a black silhouette, just an outline, all black. And there's a sort of golden patina type photograph that shines through the white screen. And it's a group of people at a rally saluting Hitler, arms up. And then you have a lot of questions like, who is this guy? What are these, if I see what these people are doing, what am I supposed to take from this? And if you ask him, what he says is, that guy, the guy you see with his arms crossed, was married to a Jewish woman, and he engaged in silent acts of resistance to the Nazi regime throughout the world, like crossing his arms in the middle of a group of Nazi sympathizers. And when I look at that photograph that was taken by a Nazi-era photographer, I see that guy. I see the fight, I see justice, I see principles. From my perspective, I grew up in Brooklyn, my cousin was murdered, a black man was dealt with discrimination. I want to draw attention to the principles of justice and racial justice, and I see him. I see courage. And that guy crossing his arms is what I want you all to see when you look at history. And then when you take the photograph, I want it to be a photograph. I don't want you to just like shine light on it, unless some other gimmick. I want it to be a photograph because I want to engage from one artist to the next. I love photography. My mom's at NYU, teaches in the photography department, Deb Willis. He says, I want you to think about the medium and take the photograph just like that photographer did. But when you do it, I want you to see the gap in his vision. I want you to see that silhouette. He doesn't see a guy with his arms crossed or racial justice or anything else. He sees that group of Nazi sympathizers. And I want you to engage with that, artist to artist, medium, crossing to different medium. And I want you to think about history. I want you to think about the role of artists. And I want you to take all that in and identify the context that that photographer was living in mind. And so when I think about what an artist is, I think of someone who can create that experience, someone who can use the visual or the auditory or the written word to create a story, a context that I think is beautiful, hideous, and important. And if you can do that, whether it's painting, photography, or a movie, or whatever else it is, if there's something that moves me, then for me, that's an art. Because for Hank to do that, and to think about the process of creating that kind of interaction with some seemingly benign print, with that kind of precision and emotional impact, that would take 5 minutes for someone to explain, 10 minutes for someone to explain, it just does it with an image. That is incredible to me. And so when I define art, that's how I define it. Making that impact, it has to be that big, small, but the ability to move someone in that way, that's what art is to me. And on the other side, what would I say? I would say that every work, no matter the medium, needs to be treated with equal respect under the eyes of the law. And when you create a photograph, you're creating a moment, just like Hank creates a moment with the viewer. You're creating a moment with the subject. You're creating an experience, you're creating an impact. And you have to make a lot of choices. So Prince didn't just show up at her place and say, take a picture of me. And she just took a bunch of random pictures with a disposable camera and he walked out. She thought about lens strokes, she thought about lighting, she thought about shading, she thought about the angle of his head, the tilt of his head. She thought about a lot of things and she created a photograph that's beautiful. It's really well done. It's art, clearly. And so if I'm on the other side of this, which I obviously disagree with from a legal standpoint, also personally I do, I would say, nonetheless, that's a work of art. And if you're going to borrow from it, you need to make sure that you're not borrowing the guts of my artistic decisions. And I would have tried to argue that when you're looking at the Warhol, the essence of the goldsmith finds its way into the Warhol. You look at his eyes, you look at his pose, you look at the opportunity to depict that person in that way that I had alone and I made use of. And then I would run to, now let's look at the world we live in. Maybe it's different in 1981 and 1984, when it's very around the internet in the way that we have it today. We can't just go out and search for imagery. Now we can just go search for imagery, find whatever you want to find. And if we don't create real boundaries for appropriation of photography in particular, then you can just borrow and borrow and borrow. And because photographers need to get their work out in the world to be able to make a living, then you're borrowing something from someone without paying them, and therefore giving them no incentive to create in the future, or at least you're diminishing their economic return on real artistic creativity, and that's not fair, and that's not right. And we need to define the marketplace so that we don't encourage people to do that. Where does it go wrong? It goes wrong because when you look at the essential elements of the label, when you look at the core of the artistic creation, the lighting, the shading, the cropping, when you look at what's left from the photograph, it is not any of the things that Goldsmith herself told me she decided artistically when making the photograph. And because of that, I don't think we should protect works that just kind of look like it, or works that are based on another work, if the second artist has not taken the core of the original artistic work. And because a person's head, or the outline of a person's head, is flat out not copyrightable, she's taken the one thing, Warhol took the one thing that the law does not protect, and really should not protect. And so I think that's how I argue it, and I think it's a reasonable argument. It's fair. I just don't think it's right.
Thank you.